And we are live. What's good, Ohio Cannabis Report family? And we have breaking news. Breaking news coming out of the Attorney General's office. Yost sues multi-state cannabis operators for anti-competitive practices. So this is what we've been waiting for something. There's only so much us little folk on the ground can do, but this is important. Stuff like this is very important. So I'm going to shout out to my guy Broderick who sent me the link. So I'm going to share my screen real quick, and then we're going to just read over this news release. All right. So Yost sues multi-state cannabis operators for anti-competitive practices. 2/6/2026. Columbus, Ohio, in an antitrust lawsuit, Ohio Attorney General Dave Yost accuses 9 multi-state cannabis operators of engaging in anti-competitive conduct to reduce product choice and keep prices artificially high, harming both consumers and smaller Ohio-based cannabis businesses. The lawsuit stems from an October 2024 tip submitted to Yost's office by an Ohio cannabis industry employee that alleged widespread, quote, self-spaced allotments, end quote, among large vertically integrated cannabis companies operating in Ohio and nationwide. According to the tip and later corroborated in the investigation, multi-state cannabis operators entered into reciprocal purchasing agreements negotiated at a national level to prioritize one another's products in Ohio's dispensaries while reducing or eliminating purchases from independent Ohio cultivators and processors. Quote, our investigation uncovered allegations of an industry-wide scheme designed to push small Ohio businesses out of the market, end quote, Yost said. Quote, Ohio's antitrust laws protect competition and consumers, not backroom deals that rig the system for a select few, end quote. According to the tip, senior representatives from large multi-state operators met in late 2022 and agreed to reduce purchases from independent businesses in order to preserve shelf space for one another during a period of increased supply and declining prices. The tip further alleged that some companies established explicit internal quotas, reserving a substantial percentage of dispensary shelf space for products sourced through reciprocal agreements with other multi-state operators. The defendants named in this lawsuit are Ascend Wellness, AYR Wellness, Cannabis Company, Cresco Labs, Curaleaf, Green Thumb Industries, Jushi, True Relief, and Verano. The lawsuit alleges each defendant violated Ohio's Valentine Act by entering into reciprocal trade agreements with competitors, sharing competitively sensitive information, engaging in discriminatory distribution practices that disadvantaged independent Ohio cannabis operators. According to the company, or according to the complaint, these actions reduced product choice and quality for Ohio consumers, stifled innovation, and allowed the defendants to maintain or increase super competitive prices in the state's cannabis market. Attorney General Dave Yost is seeking injunctive release to halt the alleged unlawful conduct. Media contact Hannah Hundley, 614-906-9113. So that's what a lot of us have been saying. You know what I mean? The prices are too high. There's something going on. These MSOs, vertically integrated companies, there's not a lot of room. Now let's go to OCAN and see which one of those, because all of those companies, I believe, are under OCAN. If my memory serves me correctly. So let's see. We'll do a side by side. What's good, y'all? We had to do a breaking news, so I'm kind of just putting stuff together. I just got home. Also, just checked out the event space for the Central Ohio Cannabis Social Equity event that's happening April 4th. Make sure you guys RSVP. We're still looking for a few more company or community sponsors, social equity sponsors. But just checked out the venue, great space. It's in Old Town East, so it'll be a great vibe. So excited for that. Shout out to Jennifer and the Ground and Grind family and her husband have created a great space for community convening. So we're excited to use their space and share information and build community there. So that's where I'm coming from. So let's see. So which companies they say? So they said Ascend Wellness, AYR Wellness, the Cannabis Company, Cresco Labs, Curaleaf, Green Thumb Industries, Juicy, True Leaf, and Verano. Okay. Then we're going to come over here to OCAN members and see which ones are on here. And some of them got different names too. So there's Curaleaf. I know GTI is on here too. Green Thumb Industries. What is this? That's green light. I think it was AYR, I think is on here too. And True Leaf, are they not on here? Oh, Cresco's on there. So yeah, it's what? 3 of the companies. That's crazy. Oh, Green Systems, they're not on there. So yeah, that's at least what 3 companies that are a part of OCAN. Hello, sorry, tapping this. Oh no, you good. I just got on. I literally just got on a few minutes ago because I just got a text message from my guy Broderick. Literally, I was looking at the event space, and then my guy Broderick hit me up at 1 o'clock. You know what I mean? So I just got to the crib. So he literally sent me the text right there. But again, I mean, that's huge. That's huge. And I mean, OCAN need to speak up because that's a couple of the companies under OCAN that's, again, going against the community. So again, let me know what you guys think. Obviously, that is a big deal. I don't know what this means in terms of like what the lawsuit will do. But people need to get sued. These companies need to get sued, bro. They are not playing fair. All right, here's the lawsuit right here. So let's see. In the Court of Common Pleas, Franklin County, complaint for an injunctive release. Ooh, and civil forfeiture. What does that mean? How to use complaints to seek injunctive release. So we're learning here. So how to use complaints to seek injunctive release. Discover how to draft a complaint that secures injunctive release in the civil cases. Learn when it's appropriate, what to include, and how to maximize your chances of success with expert legal strategies. In civil litigation, injunctive relief is a powerful legal remedy used to prevent or stop harmful action. When filing a complaint to seek injunctive relief, it's crucial to understand the legal process, the requirements, and the types of injunctive orders available. This guide will provide you with an overview of how to use complaints to request injunctive relief and when it may be the right remedy for your case. What is an injunctive release? Injunctive relief is a court order that compels the party to do something, mandatory injunction, or refrain from doing something, prohibitory injunction. Unlike monetary damages, injunctive relief is designed to prevent harm or maintain the status quo until a legal resolution is reached. It is typically used when damages are insufficient to address the harm. There is a need for immediate action to prevent irreversible harm. The legal issue involves ongoing or future conduct. Example of cases where injunctive relief might be requested include property disputes, preventing destruction or illegal uses of property, intellectual property, stopping infringement or unauthorized use of a trademark or patent, employment law, preventing wrongful disclosure of confidential information. Key components of complaint seeking injunctive relief. To request injunctive relief, your complaint must include several critical components to convince the court of the necessity of such order. These include case caption, The case caption should list the names of the plaintiff and defendant, the court where the complaint is filed, and the case number. Statement of jurisdiction. The complaint must establish the court's jurisdiction over the case. This includes explaining the court's authority to hear the case and grant the requested relief, whether based on subject matter jurisdiction or geographic location. Statement of facts. The complaint should include a detailed statement of facts explaining the situation and providing context for why injunctive relief is necessary. This section should describe the wrongful conduct or ongoing harm that warrants intervention. Explain how the defendant's actions have or will harm the plaintiff if not stopped. Provide evidence supporting the need for an injunction, such as photographs, contracts, and communications. Legal claims. The legal grounds for seeking injunctive relief must be clearly outlined. This may include specific laws or precedents that justifies the request. For example, breach of contract. If the defendant's actions violate the terms of an agreement, nuisance or trespass, when the defendant's actions are causing harm to property or rights, intellectual property infringement, if the defendant's actions threaten the plaintiff's intellectual property rights. Request for relief. The complaint must specifically request the type of injunction relief being sought. Common types of injunctive relief include temporary restraining order, a short-term injunction issued immediately to prevent harm before a hearing can be held. Preliminary injunction, a temporary order issued during the course of litigation to preserve the status quo until the case is resolved. Permanent injunction, a long-term order issued as part of the final judgment. Irreparable harm. One of the key elements when requesting injunctive relief is demonstrating that irreparable harm will occur if the injunction is not granted. This is often the most important factor in obtaining an injunction. The plaintiff must prove that monetary damages would not adequately compensate for the harm. The harm would be ongoing or permanent without an injunction. Likelihood of success on the merits. The court will also assess whether the plaintiff is likely to succeed on the underlying legal claims. The plaintiff must present evidence that their case has merit and they have a strong chance of winning. Balance of hardships. The court will weigh the potential harm to the plaintiff if the injunction is not granted against the potential harm to the defendant. If the plaintiff's harm outweighs the defendant's, the court is more likely to issue an injunction. Public interest. In some cases, the court will consider whether granting the injunction serves the public interest. For example, in cases involving environmental protection or public safety, the court may find that issuing an injunction benefits society as a whole. How to file a complaint for an injunctive relief. Draft the complaint. Start by drafting a clear, concise complaint that includes all necessary components. The complaint should fully outline the facts of the case, the legal basis for seeking an injunction, and why the court should grant the requested relief. File the complaint with the court. Once the complaint is prepared, it must be filed with the court. The filing should include the appropriate documents, such as the complaint itself and any supporting evidence or motions for a temporary restraining order, if applicable. Serve the defendant. After filing, the plaintiff must serve the defendant with a copy of the complaint and any motions filed. This is necessary to give the defendant notice of the legal action and the opportunity to respond. Request a hearing in cases involving a temporary restraining order or permanent or preliminary injunction. The plaintiff may request an expedited hearing. The court will assess whether immediate action is needed to prevent harm before the full hearing can take place. What happens after filing complaint? Seeking injunctive relief. Once the complaint is filed and the defendant has been served, the following steps typically occur. Courts review the complaint. The court will review the complaint and determine whether to issue an injunction for a temporary restraining order. This decision is typically made quickly to prevent harm. For a preliminary injunction, a hearing may be scheduled where both parties can present arguments. Defendant's response. The defendant has the right to respond to a complaint and oppose the injunction. The defendant may argue that no harm exists, that monetary damages are sufficient, and that the plaintiff is not likely to succeed on the merits. Injunction hearing. If a preliminary injunction is sought The court may hold a hearing where both parties present evidence and argue their positions. The court will then decide whether to grant injunction, trial, or permanent injunction. If the case proceeds to trial, the court may issue a permanent injunction as part of its final ruling. The court will again assess the merits of the case, the potential harm, and the public interest before making the decision. Common mistakes to avoid when seeking injunctive relief: failing to prove irreparable harm. One of the most common reasons courts deny injunctive relief is a failure to demonstrate irreparable harm. Without clear evidence that the harm is urgent and cannot be fixed through monetary damages, the court is unlikely to grant an injunction. Inadequate evidence, a lack of supporting evidence, can weaken the plaintiff's case. It's essential to provide strong, persuasive evidence to back the claims made in the complaint. Overly broad requesting an injunction that is too broad or goes beyond what is necessary to prevent harm can result in the court denying the relief. The requested injunction should be narrowly tailored to address the specific harm. So it's a mouthful right there. Let's go. So this is the also serve AYR Wellness Corporate Creations Network Inc. Cincinnati. AR Wellness Inc. So these are the defendants. HEMA LLC, Dublin Road, Columbus, Ohio. Ascend Wellness Holdings, Cannabis Company Holdings, Columbia Care. So yeah, Columbia Care, I think, was on OCAN's website. Let's see. Some of these are under different names too. Thought I saw Columbia Care in that, maybe not. Saw DeWine told us to stop whining about SB 56. Yeah, right. Are we the ones whining? Like, I feel like the politicians are the ones whining. I did see that though. Crazy. Maybe we can get some more competitive pricing. Maybe we can get some more dispensaries. Yeah, for sure. More cultivators. When Rex started, it seemed like overnight the price fix was in. Yeah, that's it. It definitely was, right? Like they definitely, you could tell. And a lot of these companies have been taken over. True Relief, once True Relief took over Harvest of Ohio. But I mean, this is big. This is big for, obviously Ohio cannabis community. I don't know what it means for, obviously the rest of like, OCAN and stuff like that. But this is positive news, more positive news than we heard in a while. So Cresco Labs, Inc., Curaleaf Holdings, Green Thumb Industries, Juicy Holdings, Boca Raton, Florida, Juicy Holdings, LLC, Eastern Comms. Look, these are the same people too. Look, GTI LLC. Look at this. So Green Thumb Industries, right? GTI Ohio LLC, 4400 Eastern Commons, Suite 125. And you come down here, it's a completely different company, right? Juicy Ohio LLC, Business Filings Incorporated. So, that's the Business Filings Incorporated. So that's the same people. True Leaf, again, Florida. Look at all these Florida companies, though. Florida, Chicago, Connecticut, Chicago. What's MA, Maine? And then Miami, Florida, New Jersey. Truly, Verano, Chicago. Mother Grows Best LLC. So Nature of Action. And only 1 year since fully legalizing marijuana, Ohio's legal cannabis market reached over $700 million in sales. Industry professionals and participants generally agree Ohio's cannabis market is projected to increase even more. The lure of success in Ohio's growing cannabis market has attracted large multi-state cannabis operators to eagerly clamor for Ohio's consumer dollars. But these multi-state operators aren't clamoring to participate in the competition. They are actively suppressing it. 9 multi-state cannabis operators, Ascend, ARY, AYR, Cannabis, Cresco, Curaleaf, GTI, Juicy, Trulieve, and Verano, have combined and conspired to form cartels to limit the availability of independent Ohio cannabis companies' products to Ohio consumers. These cartels achieve this objective through quid pro quo supply agreements, sharing of competitively sensitive non-public information, and discriminatory distribution practices. These cannabis cartels' goals is straightforward: eliminate independent Ohio rivals and keep Ohio cannabis prices artificially elevated compared to declining prices in other states. These 9 multi-state cannabis operators have a history of using these cartels to harm cannabis competition in other states, not just Ohio. They have systematically leveraged their operations in other states to diminish competition, and now they are applying the same anti-competitive strategies in Ohio. Until now, the cartel's activities have gone unchallenged. Ohio. So it's been a year of this, obviously. It's been 6 years because a lot of these companies were already doing business in medical. 6, the Ohio Attorney General brings this action to enforce Ohio's antitrust law by uprooting defendants' secret and anti-competitive conduct that is suppressing free market forces in Ohio's cannabis market. Jurisdiction and venue. The state of Ohio brings this action to prevent and restrain violations of Ohio Revised Code 1331-01. This court has subject matter jurisdiction over the actions pursuant to the Ohio Revised Code. We need to sue OCAN next. OCAN need to be getting sued because they on that bullshit. The state of Ohio further brings this action for injunctive relief pursuant to Ohio Revised Code 109-81. The court has personal jurisdiction over defendants because they are regularly regularly transact business in Ohio, contract to supply goods and services within Ohio, have caused torturous injury by acts or omissions in Ohio, and have caused torturous injury in Ohio by acts or omission outside of the state directed at Ohio while regularly doing or soliciting business, engaging in or persistent courses of conduct, and deriving substantial revenue from goods used or consumed or serviced rendered in Ohio. Venue is proper in the county pursuant to Ohio Revised Code. The parties, as of Chief Law Enforcement Officer for the state of Ohio, the Ohio Attorney General brings this action in a sovereign capacity on behalf of the state of Ohio. For purposes of this enforcement action, the Ohio Attorney General is the only plaintiff party, and no other Ohio state agency is named plaintiff. Pursuant to Ohio Revised Code 1331-11, the Ohio Attorney General is authorized to institute and prosecute actions on behalf of Ohio to enforce the provisions and remedies of Ohio's antitrust laws, codified in Ohio Revised Code, Chapter 1331. Pursuant to Ohio Revised Code 109-81, the Ohio Attorney General is authorized to do all things necessary to properly conduct any antitrust case and to seek equitable relief as provided in Ohio Revised Code. Ascend Wellness Holdings, Inc. is a corporation organized and existing under the laws of Delaware with its principal place of business in New Jersey. Ascend owns and operates subsidiary cannabis facilities in Ohio, such as HEMA LLC, Maricron Pharma LLC, Ohio Patient Access LLC, and Ohio Cannabis Clinic LLC. Ascend is engaged in the business of inter alia, cultivating, processing, and dispensing medical and adult use cannabis products in various states, including Ohio. AYR Wellness, Inc. is a corporation organized and existing under the law of British Columbia with the principal place of business in Florida. AYR owns and operates subsidiary cannabis facilities in Ohio, such as Parma Wellness Center, LLC, AYR Wellness, Daily Relief, LLC, Twice the Wellness, LLC, Good Day Dispensary LLC, and Heaven Wellness LLC. AYR is engaged in business of cultivating, processing, and dispensing medical and adult use cannabis products in various states, including Ohio. Cannabis Company Holdings, Inc. Cannabis is a corporation organized and existing under the laws of British Columbia, with its principal place of business in Massachusetts. Cannabis owns and operates subsidiary cannabis facilities in Ohio, such as Columbia Care Ohio LLC, Corsa Verde LLC, Cannabis Ohio Processing LLC, Greenleaf Medical of Ohio 2 LLC, Cannabis Alternative LLC, and Cannabis Alternative Logan LLC. Cannabis is engaged in the business of cultivating, processing, and dispensing medical and adult use cannabis products in various states, including Ohio. Cresco Labs LLC or Inc. is a corporation organized and existing under the law of British Columbia, with its principal place of business in Illinois. Cresco owns and operates subsidiary cannabis facilities in Ohio, such as Cresco Labs of Ohio LLC, CareMed Associates LLC, Verdant Creations Marion LLC, Verdant Creations Chillicothe LLC, and Verdant Creations Newark LLC. Cresco is engaged in the business of cultivating, processing, and dispensing medical and adult use cannabis products in various states, including Ohio. Curaleaf Holdings, Inc. is a corporation organized and existing under the laws of British Columbia, with its principal place of business in Vancouver, British Columbia. Curaleaf owns and operates subsidiary cannabis facilities in Ohio, such as Curaleaf OGT Inc., RC Retail 2 LLC, Curaleaf Cuyahoga Falls LLC, Curaleaf Newark LLC. Curaleaf is engaged in the business of inter alia. I don't even know what this is. Let me look this up. Inter alia. Among other things. Is that right? Okay, so inter alia is a Latin phrase that means among other things. It is often used in legal context to indicate that a point or example mentioned is part of a larger group or list. Okay. Sometimes you just got to do a little Google search. Processing, dispensing medical and adult use cannabis products, various states. Green Thumb Industries, Inc., GTI, is a corporation organized and existing under the laws of British Columbia, with the principal practice of business in Illinois. GTI owns and operates subsidiary cannabis facilities in Ohio, such as GTI Ohio LLC. GTI is engaged in the business of inter alia, cultivating, processing, dispensing medical and adult use cannabis products in various states, including Ohio. Jushi Holdings, Inc. is a corporation organized and existing under the laws of British Columbia, with its principal place of business in Florida. Jushi owns and operates subsidiary cannabis facilities in Ohio, such as Ohio Grow LLC, Franklin Bioscience Ohio LLC, Juicy RJK Ohio LLC, Campbell Hill Ventures LLC, Canoe Hill Ohio LLC, Ohio Grow Retail LLC, Statewide Property Holdings Ohio LLC, and Juicy SPH Ohio LLC. Juicy is engaged in the business of cultivating, processing, dispensing medical and adult use cannabis. True Leaf Cannabis Co. is a corporation organized, main place of business, Florida. True Leaf owns operations subsidiary cannabis facilities in Ohio, such as Harvest Grows LLC, True Leaf Ohio Inc., and Harvest of Ohio LLC. Trulieve is engaged in the business of cultivating, processing, dispensing medical cannabis and adult use cannabis products in various states, including Ohio. As of the filing of this complaint, Trulieve does not own a processing plant in Ohio. Instead, Trulieve has an operating agreement with an Ohio processor to manufacture Trulieve branded cannabis products. Verano Holdings Corp., organized British Columbia, with the principal place of business Illinois. Verano owns, operates subsidiary cannabis facilities in Ohio, such as Mother Grows Best LLC, Green RX LLC, Ohio Natural Treatment Solutions LLC, Mother Knows Best LLC, Glass City Alternatives LLC, and Mad River Remedies LLC. Verano is engaged in the business of cultivating, processing, dispensing medical and adult use cannabis in Ohio. At all relevant times in the complaint, all defendants have transacted business in or affecting Ohio. Various other cannabis operators and individuals not named here as defendants have been parties to the agreement in combination that form the basis of the complaint alleged violations. Factual allegations. Cannabis is a uniquely regulated consumer product. At the federal level, marijuana is still considered a Schedule 1 controlled substance, making its possession and consumption illegal under federal law. It is illegal to sell and distribute cannabis products across state lines. Individual states, however, take different approaches with their state cannabis laws. As a result, cannabis production and retail sales operate at an interstate level. Ohio's legal cannabis market began in 2016 when the Ohio General Assembly passed House Bill 215, legalizing medical marijuana. Under this law, licensed Ohio entities could legally grow cannabis plants, and consumers could legally purchase certain forms of cannabis from, and I'm not going to read all this, by the way, it's 51 pages. In 2019, the Ohio General Assembly separately legalized hemp cultivation and cannabis CBD oil sales. While these products are similarly derived from cannabis family, these products have significantly lower THC, the principal psychoactive component, than dominant cannabis products. In 2022, a majority of Ohio voters approved Issue 2, and adult use marijuana became legal for residents aged 21 years or older. Under this law, licensed Ohio entities could legally grow, process, and sell cannabis products, and consumers could legally purchase approved cannabis products for recreational consumption. At the time of this complaint, the state of Michigan is Ohio's only bordering state that has also fully legalized marijuana for both medicinal and recreational use. The state of the state of West Virginia and the Commonwealth of Kentucky and Pennsylvania have legalized medicinal marijuana. The state of Indiana has not legalized marijuana for any purposes. What y'all got going on over there, Indiana? All cannabis operations in Ohio are strictly regulated by state law. When medical marijuana was legalized in 2016, the Ohio Department of Commerce established a division of marijuana control to administer the medical marijuana program, governing cannabis operator licenses, patient and caregiver registrations, and other operating rules. The eventual legalization of adult use marijuana led to the creation of Division of Cannabis Control, DCC. Within the Ohio Department of Commerce, DCC performs nearly identical regulatory responsibilities for adult use cannabis operations as the previously established Division of Marijuana Control. With cannabis now fully legal in Ohio for medical and adult use purposes, DCC currently functions as the main regulatory body for all cannabis operations in Ohio. In December 2025, the Governor Mike DeWine signed Senate Bill 56 into law, which largely consolidated and harmonized Ohio's medical and adult use cannabis laws, rolling the older Division of Marijuana Control into the DCC. DCC oversees 4 types of cannabis operator licenses in Ohio: 1 cultivators, 2 processors, 3 dispensaries, and 4 testing laboratories. A cultivator license is subdivided further into level 1 and level 2. We're supposed to have level 3 cultivators license types. The difference between these license levels centers on the amount of square feet each cultivator may use to grow cannabis. Level 1 cultivator licenses are granted the largest square footage of to grow cannabis. Cultivators grow cannabis plants for distribution either to processors or directly to dispensaries. Processors manufacture cannabis plants into cannabis products, often called finished goods, such as edibles, tinctures, topicals, and other forms which they distribute to dispensaries. Cultivators and processors create cannabis products, brands to appeal to Ohio consumers and differentiate between competing cannabis products. Examples for cannabis brands sold in Ohio include Rhythm, Savvy, Buckeye, and Mindy's Edibles. Dispensaries are retail stores that sell cannabis products to Ohio consumers. Ohio cultivators and processors are prohibited from selling cannabis products directly to consumers. Testing laboratories ensure cannabis products meet certain safety standards. Ohio cannabis operators may simultaneously hold cultivation, processing, and/or dispensary licenses, resulting in an arrangement called vertical integration. Ohio cannabis operators are neither prohibited from vertical integration nor required to be vertically integrated. As of the filing of this complaint, Ohio laws only applied 3 restrictions to vertical integration in Ohio. 1, no entity may hold more than 8 dispensary licenses. 2, no entity can hold more than 1 cultivator and 1 processing license at a time. And 3, no cultivator, processor, or dispensary can hold a testing laboratory license. There is no statutory numerical limit to how many independent cannabis cultivators, processors, and testing laboratories operators licensed operator licenses DCC can issue in Ohio. Prior to the Senate Bill 56 enactment in December 2025, there was no statutory numerical limit to dispensaries. Now, SB 56, there's 400, right? Oh, here it goes right here. Licenses in Ohio, effective March 2026, there will be a statutory total dispensary license limit of 400. Currently, there are 37 licensed cultivators, 46 licensed processors, 196 licensed dispensaries, and 8 licensed testing laboratories in Ohio. The rise of accelerating state cannabis legalization trends to rapidly open new market opportunities for cannabis operators. One effect of this trend is including the rise of multi-state cannabis operators, colloquially called MSOs. MSOs are companies that conduct cannabis operations. Y'all know what MSOs are. Because interstate distributed cannabis can be vertical integration since cannabis is emerging, involving industry. The number of MSOs nationwide has fluctuated over time. However, all 9 defendants are consistently identified by industry reports as some of the most large. So since cannabis is an emerging and evolving industry, the number of MSOs nationwide has fluctuated over time. However, all 9 defendants are consistently identified by industry reports as some of the largest MSOs with operations in the United States. All defendants are licensed to conduct cannabis operations in Ohio, and with the exception of True Relief, are fully vertically integrated across their respective supply chains in Ohio. Of the 60 Ohio counties that have cannabis dispensaries, 13 of those counties have only defendants dispensaries. An additional 7 counties have only 1 competing non-defendant dispensary alternative. In most of Ohio's counties containing only defendant dispensaries, Ohio consumers must travel anywhere from 25 to 45 miles to visit a non-defendant dispensary. While non-vertically integrated Ohio cannabis dispensaries understandably sell a variety of cannabis products, brands to Ohio consumers, even Ohio dispensaries that are owned by MSOs sell rival cannabis products alongside their own company branded products. The prohibition of interstate cannabis distribution, legal intrastate cannabis operations, and vertical integrations have created unique environments ripe for competitive abuse. Beginning at least as early as January 2022 and continuing to the present, all defendants have conspired unlawfully to restrain trade in Ohio's cannabis market through at least 3 anti-competitive strategies. 1, use of reciprocal supply agreements and dispensary shelf space allotments. 2, exchanging competitively sensitive non-public information. And 3, implementing discriminatory supply arrangements and promotional terms. First, all defendants leverage their MSO vertical integration status to enter into anti-competitive agreements with each other to supply their competing cannabis products in each other's dispensaries. Cannabis products include, but are not limited to, various forms of marijuana flower, vape cartridges and oils, tinctures, edibles, and topicals sold for medical or recreational use. These supply agreements take 2 forms: national reciprocal supply agreements and dispensary shelf-space allotments. The national reciprocal supply agreements between defendants are often called trade balances. The trade balances and other reciprocal supply agreements often leverage defendants' operations in a number of states, such as Arizona, Connecticut, Illinois, Maryland, Massachusetts, Michigan, Nevada, New Jersey, New York, Pennsylvania, Virginia, and West Virginia. These quid pro quo agreements are created and structured as follows, as the example of defendants Ascend and Verano shows. Ascend and Verano representatives meet in person or virtually before or at the start of a fiscal reporting quarter to discuss their competing national cannabis operations. At these meetings, high-level corporate executives agree to national reciprocal purchasing amounts for each month during the reporting quarter. These reciprocal purchasing amounts are frequently allocated by the state. For example, for the month of April, Ascend may agree to purchase $10,000 worth of Verano products in Massachusetts, while Verano agrees to reciprocate reciprocally purchase $10,000 worth of Ascend products in Ohio. Once the national supply agreements are reached, the individual state supply amounts are communicated to and executed by the defendant's local sales and purchasing teams. When defendants' local sales and purchasing teams run into issues meeting these purchasing quotas, defendants' high-level executives will often step in to work out solutions to meet their nationally agreed amounts. Dispensary shelf space allotments agreed are often interrelated with the National Reciprocal Supply Agreement. Defendants' MSOs nationally supply agreements inform how much Ohio dispensary shelf space is allotted between agreeing competitors. For example, at various times, defendant GTI and Ascend have agreed that they will mutually stock 25% of their Ohio dispensary shelves with each other's cannabis products. There is no commercial justification for defendants to enter into purchasing quotas for each other's cannabis products, communicate with each other about future purchase and sale of products, or allocate shelf space for each other's products from state to state. In fact, negotiation and implementation of such agreements constitute nothing more than a thinly veiled See, when you get in that legal work, that legal subterfuge by which Ascend, GTI, Verano, and other defendants carry out unlawful exclusionary allocation schemes to the harm of an independent Ohio cannabis operators. At the national level, the reciprocal supply and dispensary shelf space agreements are entered into with minimal or no discussion regarding product quality or consumer preferences. Not only do the foregoing reciprocal supply and dispensary shelf space agreements restrain trade between the defendants, but they are also intended to choke off retail channels for competing cannabis products. Then the inevitable effect of these reciprocal agreements is that the independent Ohio cultivators and processors face artificially, and anti-competitively constructed barriers to winning shelf space in defendants' Ohio dispensaries. These agreements limit consumers' access to cannabis products sourced from cultivators and processors not affiliated with the defendants and erect a barrier against sale of such products in Ohio dispensaries under the control of the defendants. For example, a December 2024 email between GTI Senior Vice President of Sales and Cannabis President explained the effect of GTI's Ohio reciprocal strategy. Quote, I have materially changed how we buy and who we buy from at our retail stores because we have come to understand that at this point, this is a distribution game where I have eliminated some vendors from our stores that were not selling well enough to justify carrying their products, but also focused on the fact that those vendors were not buying any products from our wholesale business, end quote. By entering into the foregoing agreements for control of each other's cannabis products, defendants have reduced or eliminated competition between and among them for cannabis products in Ohio, limited retail shelf space for cannabis products sourced from cultivators and processors not affiliated with the defendants, and fixed and stabilized cannabis prices, all to the damage and harm of the Ohio consumers, which Ohioans have been complaining, the price is too high, I'm going to Michigan, right? Or I'm gonna just go to the head shop and get some Delta 8, Delta 9, whatever. Ohio consumers in violation of the Valentine Act. The National Cannabis Supply Meeting and arrangements also provide regular opportunities for defendants to engage in a second anti-competitive activity, sharing competitively sensitive non-public information. Two categories of competitive information are regularly shared between or among defendants. First, defendants share plan for promotion of their competing cannabis products at their Ohio dispensaries. In a market free from unlawful collusion, promotional plans are highly confidential and protected by their owners to prevent discovery by or disclosure to competing firms. Dispensary promotion information sharing revolves around planned promotion timing and discounts for qualifying cannabis products. For example, in March 2024, defendant True Relief communicated to defendant GTI that it planned to run a 40% discount off GTI's products at a True Relief Ohio dispensary for 3 days. Information sharing about promotional plans facilitate defendants' goals of keeping prices artificially elevated, and it serves the practical benefit of supporting defendants' reciprocal trade agreements. Once aging inventory is disposed of through promotions, a defendant has added motivation to purchase from another defendant the cannabis products which it had committed to purchase in the reciprocal trade agreement. By communicating competitively sensitive non-public promotional plans in advance, defendants signal to each other that the promotions are in line with their unlawful reciprocal trade agreements and are not intended to cheat on the cartel. Defendants readily exchange confidential promotional information in furtherance and in order to ensure success of the exclusionary allocation scheme detailed in paragraph 55 through 66 above. Woo! The second type of competitive information exchange between or among defendants in distribution in retail terms for non-MSO products at their Ohio dispensaries. The defendants share what prices they pay for non-MSO products, the size of supply discounts they have been granted by non-MSO cannabis operators, how many non-MSO products were sold at their Ohio dispensaries, and retail discounts each offers on non-MSO products. In a market free from unlawful collusion, this kind of pricing and discount information is highly confidential and protected by the retailer to prevent discovery by or disclosure to competing firms. The purpose of this non-MSO product information exchange is to prevent competition in the sale of cannabis products in Ohio by ensuring that the defendant have access to details about each other's commercial dealings with non-MSOs. Defendants readily exchange this confidential information in furtherance and in order to ensure success of the reciprocal dealings and schemes detailed in paragraphs 55 through 56. Defendants supply agreements and competitively sensitive non-public information exchange fuel a third anti-competitive activity, cannabis supply and promotional terms discrimination towards non-MSO dispensaries. To ensure the success of their reciprocal supply agreement scheme, defendants offer each other cannabis products discounts not offered to non-MSO dispensaries. These discounts, sometimes called front-load discounts, rebates, or vendor credits, are offered to encourage defendants to adhere to their unlawful supply purchase commitments and dispensary shelf space allotments. For example, in March 2025, defendants AYR and Verano agreed to value AYR's bulk flower at a rate significantly lower than normal market rates in order to offset money owed by AYR to Verano as a result of their reciprocal supply agreements. The discounts additionally provide greater retail margins on products sold by defendants. Defendants have combined and conspired to implement this discriminatory pricing program for their collective advantage and to restrain trade in cannabis products in the state of Ohio. Because of these discounts, Ohio non-MSO dispensaries face a difficult choice when setting retail prices for defendants' products. They may either keep the price of defendants' products higher because their wholesale price is elevated and run the risk of losing cost-conscious customers, or match defendants' retail pricing and lose margin. Either way, defendants win. Defendants also frequently engaged in jointly supported promotions of each other's cannabis products at their respective Ohio dispensaries. These supported promotions are typically structured as split co-promotions. For example, defendant Verano and Curaleaf agreed to Curaleaf would run a 30% off promotion on Verano's products at Curaleaf's Ohio dispensaries. The firms agreed to a 50-50 split co-promotion. Curaleaf would take 15% retail margin hit for Verano sales in Curaleaf dispensaries during the promotion, while Verano would reimburse Curaleaf for the other 15% margin loss on Verano products sold during the promotion. Upon information and belief, these jointly supported promotions terms are not offered by defendants to the Ohio non-MSO dispensaries. Ohio non-MSO dispensaries that are not similarly offered these supported promotions terms face difficult choice when running promotions on defendants' products. They must either maintain their margins by not running promotions on defendants' products and run the risk of losing cost-conscious customers, or run unsupported promotions on defendants' products and take a retail margin hit that the defendants avoid through their anti-competitive agreements. The foregoing discriminatory schemes have been agreed upon and carried out by defendants in furtherance of fixing and stabilizing cannabis product prices for Ohio consumers and allocating markets. These are intended to restrain trade in this market, and they have had the intended effect. Defendants' anti-competitive actions harm competition in Ohio's cannabis market. According to one cannabis data analytic companies, most of the top 10 most popular cannabis brands in Ohio are grown by Ohio cannabis operators with no affiliation with multi-state operators such as the defendants. But defendants' reciprocal trade and dispensary shelf space agreements block competing non-MSO cannabis operators from reaching more Ohio consumers. Successfully obtaining an Ohio dispensary license is often not a viable alternative for small independent Ohio cultivators and processors. The lengthy licensing process requires significant capital and time investment. This retail lockout restricts the desire for cannabis choices available to Ohio consumers who shop at defendants' Ohio dispensaries, curtailing access to higher quality or preferred cannabis products. What have we been saying for years, for months at this point? My gosh. For example, in August 2024, a GTI associate buyer communicated to Ascend's vice president of wholesale about the unpopular consumer consequences of the reciprocal dealings in one of GTI's Ohio dispensaries. Quote, in an effort to maintain our spend goal, we have accumulated a large amount of inventory that does not perform at the same rate as more popular brands like Simply Herb or fan favorite strains like Butter Stuff. Defendants' reciprocal trade and dispensary self-space agreement ensure that defendants' products are widely available at retail dispensaries in Ohio, and by operation of their unlawful scheme, defendants have little or no incentive to innovate or otherwise improve their cannabis products offerings. Defendants' combination and conspiracy in the restraining of the trade in restraint of trade by additionally resulted, as intended by defendants, in super competitive cannabis retail prices for Ohio's consumer. Ohio consumers continue to pay more for cannabis products than they would if defendants were not engaged in unlawful anti-competitive conduct, and defendants continue to reap windfall profits from their illegal combination in conspiracy. Defendants' actions, as described in the complaint, are continuous and inflict continuing and accumulating harm. Cause of action, count 1, combinations by Ascend and restraining trade in Ohio. Plaintiff incorporates by reference each of the, let me see, plaintiff brings. Defendant Ascend is licensed to cultivate, beginning in at least as early as January 2022 and continuing through the present, defendant has engaged in a combination of capital, skill, or acts to create or carry out restrictions in the trade of cannabis products. These acts include, but are not limited to, agreeing to national reciprocal cannabis product supply quotas and or to allocate dispensary shelf space percentages for competing cannabis products. B, sharing competitively sensitive non-public retail plans and exchanging other cannabis competitors' supply and retail cannabis prices and competitor cannabis supply retail discounts, and agreeing on favorable cannabis supply and promotional terms not offered to non-MSO Ohio cannabis operators not participating in the illegal combination. During the relevant time period, Ascend agreed to national reciprocal cannabis product supply quotas with multiple co-defendants. September 2023, emails between Ascend Vice President and of Wholesale and GTI Senior Vice President of Revenue Detail by State 2023 quarterly reciprocal targets and actual purchases. August 2024, emails between Ascend Vice President of Wholesale and GTI Senior Vice President of Revenue detail by state the 2024 quarterly reciprocal targets and purchases of the state. Quote, following our earnings call this morning, I thought I would proactively send over revised forecasts given the increased competition and resulting retail softness we are experiencing, end quote. September 2024, email between Ascend Chief Commercial Officer and Verano, Vice President of Procurement detail by state 2024 third quarter reciprocal targets and purchases. April 2025, emails between Ascend Vice President and Planning and Purchasing and True Relief Director of Wholesale and detail by the state in April and May 2025 quarterly reciprocal targets and purchases. During the relevant time period, Ascend Wellness share competitively sensitive non-public information with multiple co-defendants. November 2022, email between Ascend's Chief Operating Officer and GTI Senior Vice President of Revenue state that the Ascend has committed to finding a creative solution to help mitigate the conflicting prices as much as possible. Ascend will initiate more regular communication regarding discounting and transparency around timing. 2023 emails between Ascend's Carroll, Ohio store to the GTI Ohio sales director containing spreadsheets detailing all cannabis products sold, their retail prices, and discounts received from non-GTI vendors. 2022 and 2023 emails between Ascend's Coshocton, Ohio store and the Cannabis Ohio facilities operation manager contain spreadsheets detailing all cannabis products sold, their retail prices, and the discounts received for non-cannabis vendors. During the relevant time period, Ascend agreed to on favorable cannabis supply and promotional terms not offered to non-MSO Ohio cannabis operators. August 2023, emails between Ascend Chief Commercial Officer and GTI SVP of Revenue detailed a wholesale cannabis deal in Ohio that would, quote, only be offered in your stores and ours, end quote, to assist with our reciprocal trade of deals. October 2024, emails between Ascend Ohio Purchasing Manager and Verano Ohio Accounts Executive state, quote, if we can get to the 40K mark spend this month as discussed, I would be happy to offer some discounts on low potency flower so you can pad your margins or use some discounted items for the outlet stores, end quote. Defendants combinations had the purpose of preventing competition in the sale of cannabis products in Ohio, maintaining or increasing prices of cannabis products in Ohio, affecting prices by uniting interests in the sale of cannabis products in Ohio, and reducing the production of cannabis products in Ohio. Defendants combinations and purposes are unlawful trusts under Ohio Revised Code. Defendants combinations are conspiracies against trade under Ohio Revised Code. Defendants agreements that are the result of an illegal trust are void pursuant to Ohio Revised Code. Competition for Ohio's cannabis products has been injured because defendants' conspiracies restrict cannabis product choices available to Ohio consumers, reduce cannabis product quality available to Ohio consumers, stifle cannabis product innovation, and maintain or increase super competitive cannabis prices. This complaint constitutes due notice of these violations under Revised Code. Plaintiff incorporates by reference each and every allegation contained in the above paragraph. Plaintiff brings action to pursue, blah, blah, blah. Defendant ARR licensed to cultivate, process, and dispense medical and adult use cannabis beginning at least as early as January 2022 and continuing through present. Defendant has engaged in a combination of capital, skill, and acts of create or carry out restrictions in trade of cannabis. These acts include, but are not limited to, agreeing to national reciprocal cannabis product. I'm assuming this is going to probably say the same thing as the other ones. This is just going through the different businesses. So January 2022, email between AYR Chief Business Development Officer and Juicy Director of National Accounts detailed by state prior 2022 reciprocal targets and actual purchases. December 2023, email between AYR Regional Procurement Director and GTI Ohio's Sales Director state, quote, I was given your information as a wholesaler for GTI in Ohio. I was also informed of the corporate level commitment to purchase for our locations, end quote. February 2024, emails between AYR Director of Planning and Allocations in the Verano, Ohio account executive state, quote, currently we are prioritizing our retail purchases with companies that are purchasing from our wholesale, the whole balance of trade routine. Since Ohio's wholesale was operating before our retail location opened, we are still catching up on our reciprocity list, end quote. September 2024 emails between the AYR Chief Business Development Officer and Verano Vice President of Procurement asked, quote, wasn't the $16K additional purchase in Ohio Pat sick of our quarter end agreement? Seems like local buyer is waiting for your direction, end quote. During the relevant time period, AYR shared competitively sensitive non-public information with multiple co-defendants. October 2024 email between AYR Chief Business Development Officer and Ascend Chief Commercial Officer discuss wholesale pricing for various cannabis vendors to assist with setting a wholesale price for AYR products to Ascend. April 2025 email between AYR Ohio Purchasing Manager and Verano Ohio Account Executive give advance notice of AYR's plan to run an Ohio promotion on Verano products. During the relevant time period, AYR agreed to favorable cannabis supply and promotional terms not offered to non-MSO Ohio cannabis operators. October 2023, email between AYR Chief Business Development Officer and Verano Vice President of Procurement detail by state discounts off frontline pricing and split promotions. March 2025 email between ARY Chief Business Development Officer and Verano Vice President of Procurement agree on a lower price for AYR bulk purchasing to, quote, offset some of the money we owe you this month and next. Then after that, we'll need to revert to fair market pricing, end quote. Defendant combinations had the purposes of preventing competition and sale cannabis products in Ohio, maintaining and increasing prices in cannabis products, affecting prices by uniting interests in the sale of cannabis products in Ohio, and reducing the production of cannabis products in Ohio. Defendants combination, blah, 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 blah. So this is just going to go through all the other ones. I'm not going to read all that. It's 51 pages. And my mouth is dry already. So let's see. So these are their attorneys, all the information. Plaintiff State of Ohio praised as follows. Woo! That was a lot of reading. I need to take a break. Oh, I need to go hit a blunt after that. There you go, hit a joint after that. All right, let me see. Crazy. Maybe we can get some more competitive pricing, hopefully. When Rex started, it seemed like overnight pricing was fixed. The Attorney General filed this. Yeah, the Attorney General. This comes from the Attorney General, but I think it was somebody tipped them off. So I think somebody from inside the cannabis industry tipped off the Attorney General. They did an investigation, and the Attorney General basically did the lawsuit. So here's the if I can find the. So here's the news report that. Share my screen again. So here's the original article, the news release. So Yost sues multi-state cannabis operators for anti-competitive practicing. So yeah, support your local growers, people. Support your local growers. That's all I got for y'all today, though. I mean, again, it was breaking news. I just got that text, so I wanted to make sure the people of Ohio Cannabis Report got that information. Again, make sure you guys like, comment, subscribe, share the content. Also, this is for educational entertainment purposes only. We're not lawyers, we're not doctors, none of that nonsense over here. We are an independent media platform, just sharing the news. Don't shoot the messenger. You know what I mean? So appreciate you tuning in, folks that tuned in. Thanks to everybody who's been supporting. We're almost at 200 subs on our YouTube. So hopefully by today's Friday, hopefully by next week, mid next week, we hit our 200 sub mark. Make sure you guys are sharing the content. Make sure you guys are commenting, liking, doing all that stuff. Please support. Again, we have an event coming up, the Central Ohio Cannabis Social Equity Event and Forum will be April 4th. Get your tickets, RSVP. This is a free event open to the public. And this is a community event. So please don't come with the bullshit. I'm not a politician. You know what I mean? Like, I'm not a millionaire. So I'm just trying to create safe spaces for us to have conversations around social equity, around ways to move forward with the new, obviously, SB 56 law. Again, SB 56 was signed into law, and it was supported by OCAN, which some of these multi-state operators are a part of OCAN. And so, obviously that hurts everybody. So SB 56 is going to add fines, criminal penalties. If you go up to Michigan to go get cheaper weed, bring it back. Combustion in the car is now a fine, criminal offense. Driving with cannabis, if it's not stored in the trunk, it has to be unopened, has to be the farthest part behind the driver's seat. No more public consumption with SB 56. SB 56 guts the social equity program. So there's no, some of the funds have been released to local communities, but there was another allotment that was also supposed to be added on to that was taken out. What else? They capped dispensaries in the state at 400 with SB 56. What are some other? It adds discrimination language, probable cause language. So, again, if you're driving, you get pulled over, cops think you smoke weed, assume you smoke weed, they can now take you out of the car, do all sorts of things. Now discrimination in healthcare. If you need an organ transplant and you smoke weed, consume weed, they can deny you that organ transplant. It adds language for people, employers to fire you. If you get fired for cannabis, or they can randomly drug test you. If you fail the drug test, they can fire you. Obviously, Ohio is an at-will state. So then you lose your unemployment benefits, gives landlords more leeway to evict folks for cannabis and stuff like that. So SB 56 is not what we voted for. And OCAN, Adrian Robbins, who is one of the executive directors, David Bowling, they have said multiple times that SB 56 is what the people voted for, and it is damn sure not. And I know what I voted for when I voted for issue 2. I voted for social equity for sure. I voted for public consumption for sure. I voted for homegrown for sure. You know what I mean? I voted for being able to share cannabis with friends, family, community for sure. So I didn't vote for this, what they got going on now. I definitely didn't vote for that. So again, no to SB56.com is the website if you want to get involved with the petition signing that is happening. They did get it agreed to by the Attorney General, so they have to get 240 something thousand signatures. So make sure you guys are registered to vote. And they're trying to get this on the November ballot. So yeah, that was a lot of reading though. So I need to go take a break. But I appreciate y'all for tuning in. Hope y'all have a good rest of y'all day. Peace, blessings, and love. We out.